Hello everyone, this is Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. So this is the second part of the analysis of protection of women against the Domestic Violence Act 2005. In the first part, I had gone through the introduction section. Further, I had dealt the types of abuse covered under the Act. And in this section, I will be dealing with the procedure involved under this Act. So, starting from step 1, that is informing the protection officer. Any person who has the reason to believe that domestic violence has been or is likely to be inflicted upon her can inform about the same to a protection officer appointed under section 8 clause 1 of the Act. It would be better if such a protection officer was a woman herself. Such woman would be informed of her rights by the protection officer, a police officer, service providers, any voluntary associations registered under law working with the objective of protecting the rights and interests of women, or a magistrate who has received the complaint or was presenting when the offense occurred. These rights are: such women have a right to make an application obtaining relief in the form of protection, monetary relief, custody order, residence order, compensation order, and others. They also have a right to make use of the service provided by the available service providers. They also have a right to make use of the service provided by the protection officers. They have a right to free legal services under the Legal Services Authority Act 1987. They also have a right to file a criminal case under section 498 clause A of the Indian Penal Code. It must be mentioned here that if the appointed protection officer does not perform his or her duties, he or she can be liable to imprisonment up to 1 year and fine up to ₹20,000. So now coming to the step 2, that is making a domestic incident report by a protection officer. Upon receipt of the domestic violence complaints, the protection officer must take a domestic incident report to the magistrate. The report should also claim relief for a protection order if the aggrieved person desires. Such magistrate to whom the report was made would be a magistrate of first class or the metropolitan magistrate who is exercising jurisdiction in the area where the aggrieved person resides temporarily, respondent resides, or the place where domestic violence allegedly took place. And further, the copies of the report should be forwarded to the police officer in charge of the police station within local limits of which the domestic violence allegedly took place. Apart from this, it is the duty of the protection officers to ensure that the aggrieved person gets all the benefits as mentioned as her rights and maintains a list of the service providers, shelter homes, and medical facilities in an area. So now coming to the step 3, that is application with the magistrate. Once an application is filled to the magistrate by the aggrieved person, someone on the behalf of the aggrieved person or a protection officer, the magistrate will fix the date of the first hearing. Such a date is usually not beyond 3 days from the date of the receipt of the application by the magistrate. Also, the magistrate will endeavour to dispose of the application made within 60 days from the first hearing. Now coming to the fourth step, that is notice to the respondent. That is, once the date of the first hearing has been set by the magistrate, a notice shall be given to the protection officer who shall inform the informant and any other person prescribed by the magistrate. This shall be done by the protection officer within 2 days from the date of receipt unless an extension is given by the magistrate. Further, the fifth step, that is other options that the magistrate can make use of. Under section 14 of the Act, the magistrate may ask the respondent or the aggrieved party singly or jointly to undergo counseling with a member of the service provider. Such a person must have experience in counseling. Under section 15 of the Act, the magistrate can take the help of a person, preferably a woman, for discharging his functions. Such a person should preferably be working in promotion of family welfare. Now, that is step 6, that is giving orders. So orders should be of a few types like protection order, residence order, monetary relief, custody order, or compensation orders. Further, the last step, that is step 7, which deals with the steps to take in the case of breach of the order given. In case the respondent breaches the protection order given by the magistrate, he shall be liable under this Act. He shall be liable with punishment up to a term exceeding to 1 year or a fine at maximum 20,000 rupees. So, at last, the Protection of Women and Domestic Violence Act 2005 was implemented in October 2006. It is a very promising legislation that combines civil remedies and criminal procedures to provide effective remedies to the women who become victims of domestic violence. The Act provides for the protection officers medical facilities free of cost, which helps the aggrieved women in protecting themselves and their loved ones. However, the Act is not free for a certain problems. Clearly, the implementation of the Act needs to be made more concrete. The Human Rights Watch has found that the police often do not file a FIR. That is the first step to initiating a police investigation, especially if the aggrieved person is from an economically or socially backward community. Most of the domestic violence, sexual violence, and martial rape cases in India never go reported. Lack of trained counselors who can help domestic abuse victims and little access to legal aid also adds to the mystery of these victims. Issues like these need to be solved so as to ensure that women get the justice they truly deserve. That's all for now, and thanks for watching. Let's see you in the another session. Please do like and subscribe the channel. Thank you.